This is Moscow. This is Moscow Courtroom. On the 12th of April, the Soviet Union orbited a spaceship around the Earth with a man on board. The astronaut is a Soviet citizen, Major Gagarin Yuri Alexeyevich.
Okay, go ahead. May it please the court, your honors. I'm Zachary Ayers on behalf of the appellant, Jonathan Allen, in this case, and I reserve 5 minutes of my time for rebuttal. The four issues I want to approach the court with today, first starting off with vouching, prosecutorial misconduct.
The state needs to testify to the facts contained herein under the penalty of perjury that this man is accused of these crimes and we have probable cause to move this case forward. Well, what just happened was instead is I went down there, your little buddy, the prosecutor, refused to talk to me, and I've been asking for disclosure for 4 weeks, and he refused to talk to me. And then when I got in front of the judge attempted to move forward with an arraignment that lacks probable cause. The judge had no police report in his hand because you don't have a police report in your hand because they haven't given it to you. So the fact that you allowed an arraignment to move forward when at the moment that my arraignment took place, you will now need to testify in federal court under oath in a deposition how you felt under the law as it's written, ARS, you felt you had probable cause to move forward with charges when you don't even have a police report. And then I'm holding an order that says no contact with any victims. Who's the victim? Name them. Put a name to a victim. There's no...
You may also experience shooting pains in your pelvic and crotch area. This can feel a little bit like electric shocks, and it's known as lightning crotch in the birth world.
Victim.
I do have the name of the person that is the named victim. Just one moment. I'm going to look at...
Good, because I can get that lawsuit against him going.
In our file, and I'm opening up the police report, and I'm going to look under what the police designated as a victim.
So you have a copy of the police report?
I do.
Why wasn't it at my arraignment?
Jordy, I want to, sir, as long as you let me answer your question, I'll be happy to answer your question. But if you don't let me answer it,
go ahead.
I'll let you talk yourself.
Go ahead.
Jordy, Jordi.
Sweet.
Amador Perez. So Jordy.
First starting off with speedy trial.
As defendant requested a continuance and he's excluding me, so he's saying that my time stopped and you could take 2 years now to give me a trial. I did not waive my right to a speedy trial.
It is our position that the district court abused its discretion when finding a dismissal without prejudice.
The world's first cosmonaut. The first to open the door into the unknown. The first to step over the threshold of our homeland.
He wants to take public tax money but not face public scrutiny. That's called the opposite of a public servant. That's a thief of taxpayer dollars.
Vouching, prosecutorial misconduct, and...
This man gives a 56-minute video on the internet of how to manipulate the disclosure system. It's called Disclosure from a Shield to a Sword. That's a controlling, let's control you with the law. Let's take our money from the very same people we took an oath to protect and serve, and let's do anything. Hey, Your Honor, would this be, can we deal with this now? All right, so Matt Walker, the state, he has a 56-minute presentation for the prosecuting attorneys union where I'm gonna, and this might be admissible evidence.
Let him finish.
Okay, so on the so in my research, so Matt Walker, the state, he has a podcast for continuing education that's listed on the Union of Prosecuting Attorneys or something. And what is it, CPAP or APAP? Right, okay. Where in that 56-minute presentation, he gives a presentation on how prosecutors can weaponize the disclosure system to protect the state from unlawful, like if they unlawfully arrest somebody.
Third and fourth, if time permits, the grand jury issue, and then the...
I don't think that's valid of a conflict. I don't think that would, because the reason, and you know, you have your position of why you wouldn't think that's a quote-unquote legal conflict of interest, and I have my position why I don't think it's a legal conflict of interest. But on top of that, I would say that whatever legal conflict of interest they determined, it would have been there when the case, as soon as I got arrested. And so how did it get to this point to where they internalized this is a conflict of interest? And I'm saying, so it's like, so we can only take it at face value and then react to it, you know what I'm saying? And our hypothesis is, oh, it's the mayor, the city council. Well, I don't think that's a good enough excuse. And if that is the reason, then it should have been brought out sooner. That's my position.
So you're entitled to file an objection to that. I'm not going to be objecting.
Objecting to the moving of it? You mean to the objection to move it?
Yeah, you can
Right,
file
right. No, I know. I see what you're saying. Right.
So, but as far as your other question about, you know, that there's been disclosure, etc. So the way it works, and again, you can believe me or not, a couple different principles of law here. The Justice Court and the City Court are both entitled to hear cases that originate within Pima County. So the Justice Court has concurrent jurisdiction with Tucson City Court over these matters. So cases do get moved back and forth, you know, with some regularity. The second thing is, until a judge has made any firm decisions in the case, there's no prejudice. So it's not as though Judge Crenshaw has made a bunch of adverse rulings to you and then decided to transfer the case. He hasn't ruled on anything.
He actually did, though. Can I pump the brakes for a second there? That's what I'm going over. This is an adverse ruling because this order says defendant requested a continuance and he's excluding me. So he's saying that my time stopped and you could take 2 years now to give me a trial. I did not waive my right to a speedy trial, and that's what I'm saying. This is a order, and that.
If you want to do this, you can file something. You can put this in there if you want. You can say that you're not waiving your right to a speedy trial. You can tell them that you consulted with the prosecutor. The prosecutor's fine with that. We understand that you didn't waive your right to a speedy trial. Or the thing is, courts can retroactively include or exclude time. So when this case does end up in front of Justice Court next time, or wherever it goes, we can make a record that you are still invoking your speedy trial rights, and we have 6 months to bring the case to trial.
No, I get what you're saying. Right. No, I get it. We can always, right. We can, but what if they take more than 6 months to give me, because once they click that, they're not on the clock, and so then their computer giving me a court date, they might be like, oh, and the court date might be outside the 6 months.
So at that point, you could file a motion to dismiss under Rule 8.
Right. No, I know what you're saying.
So there you go.
So look, and there's no, and we can agree on this. I don't want to get petty, but like, okay. So you're saying he hasn't made an adverse ruling. I believe that he did give me an adverse ruling by calling her the victim when it's listed in the reports as a witness, and everybody I've talked to, including the police department, the arresting officer, the videos, everybody I talked to is going to testify she's the witness, not the victim. So I don't know where you came up with that. I don't want to argue with you about it right now, but I'm telling you that I got to call you out on that in paper, in filings, because that's not what the police report says. That's not what the officers are going to testify. That's not what the Tucson Police Department's going to testify. That's not what O'Reilly Corporate's going to testify. That's not what MJ Raciti told me on the phone. But like I said, you have your position. So what I'm saying is, since the first week of June, we're in the last week of September.
So this event occurred
May 20th.
Allegedly, okay, May 20th.
And May 26th. So what? I didn't. Okay, so
We'll go by the earlier date.
the day I got arrested for the May 20th on the 26th. You get what I'm saying? Okay. So, but it starts from the 20th because that's what he wrote.
Well, Rule 8 is from the arraignment date.
No, it's not. I was arraigned, sir.
Rule 8 is from the arraignment.
Unless you're issued the citation and released, which I was, which could constitute my first appearance, when the cop issued me the citation and let me leave. And now if I was taken to jail, it would start from the arraignment.
Mr. Myers, you can file a motion arguing that point.
Okay. Rule 8 is
What
from
I'm saying is, so we want to set a evidentiary hearing.
Please not October 15th. That's my birthday.
We won't do that. That's too soon after the interview.
The state's,
Right, no, I'm going to be celebrating the interview on my birthday, though, that's for sure.
state's available on the 15th, Your Honor.
No, we're not doing it.
See how this dickhead just tried to get that hearing on my birthday just to play? You see what's going on, Rijoas? I got him by the balls, if he even has any. These days, you never know. He might be identifying. I get it. I get it.
I'm asking.
He doesn't get to hide from the case, and then when I see him, I feel you, sir. I respect your courtroom. I want a fair trial, and I'm going to respect you. But he's had 4 times. 3 other judges have asked him all these questions, sir. And somehow I got yelled at in court and told to sit down, and he didn't get none of these. I appreciate and commend you, sir, for fucking. Because none of the other judges would do it. They said, I don't want to be involved in this because I know what's going on right now.
I'm going to check officer scheduling, Your Honor.
Yeah, go ahead.
Yeah, you bet they're courting, you know what I mean? So how fair is it that the person who's innocent to proven guilty? First of all, how did a student know who Myers even was? And second of all, how did the student, this 18 to 22-year-old who's about to get roasted through this legal process now, how did this student determine why? First of all, how did this student know who Myers was? Why would this student think that if they saw Myers in his car, that was a problem? Were they notified to contact if they see this guy? He's not okay, because if I could only not go to that building, why would a student be reporting me 115 feet from a building that I'm allowed to be 3 feet from? And more importantly, if I'm allowed to be 3 feet from the building, why was I being arrested for being 115 feet from the building, regardless of what I was doing, if I was allowed to be on the university campus, just not enter that building at the time? So if I was just not allowed to enter the building at that time, and I could stand, so here's the building, right? And they told me I could walk right here, I could walk right here, I could walk right here, because this building's only open 8 to 5. So are they saying at 10 o'clock at night? What I'm getting at here is that the address that they said I couldn't come to is the public library at the university. It's public. So they took away. Now they're saying that if I go there, it's not only trespassing, but it's an injunction for harassment. I mean, it's a violation of an injunction. Get out of here. It's public property. You can't take away my right to public property without, I've already have. If the testimony is that he came to my place of work, then why wouldn't 132916 does not apply to constitutionally protected speech? Let's just pretend that. Let's just pretend that he came into my house, even though it was my workplace. So if the testimony is that he came to my place of work, then why wouldn't it be an injunction against workplace harassment? There's no allegations of coming to this person's house. So if they came to their work and not their house, why would they be banned from going to their work, which is a public building, if they've never been there in any other capacity that was lawful? So how could they prohibit speech or other activities such as freedom of petition, the right to assembly, the right to address grievances? How could Judge Dawn Walton, Commissioner, Family Law, take away the right of the First Amendment when the law, we're not even arguing about this or that. We're literally saying that there's an Arizona statute that says you cannot apply this to First Amendment or constitutionally protected speech or activity, right? Speech
is ordered sealed.
Oh, wonderful. Thank you.
Hopefully that will.
I appreciate it.
I would follow up to see.
I will.
If
I will.
was done. Let's see. Someone can tell me if I'm not supposed to do that.
Thank you. Oh, great. Thank you very much.
All right. Thank you.
Thank you both. I hope you have a good evening.
The harassment that he is inciting through those. So,
and I think those could possibly be seen as third-party contact, et cetera, and I think that's going to depend on how the prosecutor's office wants to interpret that.
Understood. Thank you.
Okay. Do you have any more questions for me today? Is there anything else I can do for you today?
Sorry, I just want to ask a question. Can you just ask specifically about future videos if that's income restricted?
Your Honor, does this order, injunction against harassment does it encompass any future videos?
It should.